and oh wow. Wow, that was crazy. Hi, and welcome to another episode of Diary of a Migration Lawyer. Today we're going to be talking about the public interest criteria, particularly PIC 4020. So let's start with what even are public interest criteria. Well, as the name would suggest, the public interest criteria sit in Schedule 4 of the migration regulations. What they serve to do is to regulate things that are in Australia's public interest. So, for example, things like health or character, or if someone's telling the truth on their visa application when they're trying to meet the visa criteria. For today's episode, I'm going to focus on PIC 4020, the false information and bogus document PIC. To get started, what I want to do is read a bit of an excerpt from a case to really understand what this means. So in the case of Trivedi, the court held that to refuse a visa based on PIC 4020, it is necessary that the information or document have the quality of purposeful falsity, whether or not the visa applicant can be shown to have personal knowledge of that fact. So what does that even mean? So essentially what that means is if a false information or a bogus document is submitted to the Department of Immigration or Department of Home Affairs on your visa application, it means that you can be held responsible for the department receiving that document or information. So really, it doesn't matter if you didn't know that document was submitted or that information was provided on your behalf, you are still going to be held responsible for it. Purposeful falsity essentially means that something is purposely false and given for the intended purpose of trying to meet a visa criteria by providing false or bogus information. So it's a little bit scary. And the effect of having a visa refused on the basis of PIC 4020 means that A, you have a visa refusal, and B, you are barred from being granted any further Australian visas for the next 3 years from the date of that decision. So the outcome is quite a scary one and certainly not a predicament that you want to find yourself in. So in applying PIC 4020 to a visa application, the department must be satisfied that there is no false or misleading information in the current visa application or in any visa application that has been made within the 12 months prior to that application. If the department find out that there is any funny business going on, it must be found there's factors outside the applicant's control as to why that information or document was provided, or there must be compelling or compassionate reasons that affect Australia or Australians, and that PIC 4020 then would be potentially be considered waived. The bar is pretty high to seek a waiver of this requirement, so the case for the applicant must be really strong. That is today's episode of Diary of a Migration Lawyer. A little bit scary, but if you do have a PIC 4020 issue come up, come talk to us. We'd love to give you a hand. Otherwise, like, comment, subscribe. Thanks for watching. Thanks for watching Diary of a Migration Lawyer. If you would like some more hints, tips, tricks on how to do migration yourself or with a strategic partner like a migration lawyer, don't forget to like and subscribe to our channel, Diary of Migration Lawyer.